my own world of make-believe. Kids screaming in the cradles, profanities. I see the world through eyes covered in ink and bleach. Cross out the ones who heard my cries and watched me weep. I love everything. Fire spreading all around my room. My world's so bright, it's hard to breathe, but that's alright. Hush. Tape my eyes open to force reality. Why can't you just let me eat my weight in glee? I live inside my own world of make-believe. Kids screaming.
Hey, what's up, guys? Now, what do we know about death penalty cases? There's certain aggregators that goes into a death penalty case. Well, one of the aggregators that Ann Thompson has been arguing is the fact that it should only be brought up if there's a speedy trial. And she's stating that since Brian has waived a speedy trial, the aggregators for the death penalty case, it should be taken off the table altogether. Comes now, Brian C. Kohberger, by and through his attorneys of record, hereby moves to strike the state's notice pursuant to Idaho Code 19-4004A on the grounds that there was no check on the decision of the prosecutor to pursue the death penalty. This motion is based on a motion to strike notice of intent to seek the death penalty on grounds of failure to prevent aggravators to neutral fact finder. 5th, 8th, and 14th Amendments of the Constitution of the United States and Article 1, Sections 6 and 13 of the Idaho Constitution. The Constitution requires a neutral fact finder to determine where the death penalty may be pursued. The process provided to Mr. Kohberger up to this point has failed to adequately protect him from being arbitrarily selected for the death penalty in violation of the 8th and 14th Amendments, and that no check was placed on the discretion of the prosecutor. The prosecutor has previously told this court what the state is trying to do is to enforce the law that our legislator has put in place that says in cases such as this, in facts like this, a jury is entitled to decide not only guilt but potentially penalty. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying and is wanting and is trying to kill someone is just simply appealing to raw emotion, and it has no place in this courtroom. However, as the prosecutor knows from his own experience in refusing to pursue the death penalty in State versus Lee, the decision to pursue the death penalty falls entirely and unreservedly to his own personal decision. See Martin Trillhouse as Idaho's death penalty faces in its own morality, available at the Spokesman Review, March 17, 2016. Selecting a candidate for death in Idaho, the decision to pursue the death penalty is the prosecutor's IC 18 4004 provides the penalty for first degree murder is death or life imprisonment, but may only be death where the prosecutor files notice of their intent to pursue death in IC 18 4004 provides the prosecutor may drop their pursuit of the death penalty at any time. If they do so, the death penalty cannot be the outcome of a case. Okay, she's stating right there that Bill Thompson not wanting to stop the pursuit of the death penalty is his own selfish need, that he wants to see this man dead, which I do not agree with. If she's stating the legislature says and the Constitution says at any time he can drop this death penalty off the table and go for a life sentence, but he's not wanting to do that. He's basically trying to kill Brian. He's trying to kill an innocent person. The only limitation on the prosecutor's ability to seek the death penalty then is that it be a first degree murder case, and the prosecutor can find one circumstance of the case called a statutory aggravator. As explained in detail in Prosecutor Kohberger's narrowing death eligibility in Idaho, an empirical and constitutional analysis, due to the broad and vague nature of both what constitutes murder and what constitutes an aggravator, almost every murder is eligible for the death penalty at law. Professor Kohberger and her team analyzed first and second degree murder cases in Idaho filed between June 2002 and the end of 2019. They found that 86 to 90% of all murder convictions were factually first degree murder cases, and that 93 to 98% of those factual first degree murder cases were eligible for the death penalty under Idaho's scheme. In fact, the scope of Idaho's death penalty is constitutionally defective in its own right and will be argued in a separate motion. Thus, there is no jury entitlement to the death penalty. There is only the decision of the prosecutor that sets the defendant upon this path. The consequence of placing no check on the prosecutor's discretion to seek the death penalty is a system in which the geography plays the largest role in determining whether the accused will possibly be executed, as Justice Breyer found out. And Justice Breyer is one of the Supreme Court justices in the United States, up in Washington, D.C. Motion to strike notice of intent to seek the death penalty on grounds of failure to prevent aggravators to neutral fact finder. Some studies indicate that the disparity in charging reflects the decision-making authority, the legal discretion, and ultimately the power of the local prosecutor. See Greg Goldhauser, prosecutorial discretion under resource constraints, budget allocations, and local death charging decisions. Catherine Barnes et al. Place matters most. An empirical study on prosecutorial decision making in death eligible cases. See Arizona, as back in 2009, analyzing Missouri, Donahue, Connecticut, Justin Marceau, death eligibility Colorado. Many are called, few are chosen. The Fifth Amendment requires that a grand jury pass upon any case involving the death penalty. That right, as Mr. Kohberger has argued previously, was intended as a shield against government run amok. Motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative to remand for preliminary hearing. The origins of the adversary criminal trial, that's from 2003. It was so revered by the colonists that Madison enshrined it in the Fifth Amendment, even as Hamilton argued against it. You know, we're talking about two of the very early presidents here in the United States. Despite this, the Supreme Court in Hurtado versus California, 110 U.S. 516, 1884, determined that the amendment should not apply to the states through the 14th Amendment. The Supreme Court in Hurtado held that the grand jury requirement was simply a choice made by writers of the federal Constitution. Basically, what she's saying here, guys, Ann Taylor is stating that if the death penalty is on the table, then this grand jury that Bill Thompson impaneled should have passed on the grand jury hearing. So, in effect, that grand jury that Bill Thompson impaneled should be null and void because he came out with the death penalty way before he had this grand jury impaneled, or the secret grand jury. So that grand jury finding is null and void. They should have passed on it since the death penalty was already on the table. And that shows you right there, guys, just how crooked Moscow, Idaho is. The Supreme Court in Hurtado held that the grand jury requirement was simply a choice made by the writers of the federal Constitution, and certainly not one required by due process, if only because the words due process appear in a separate clause. The court that held that the words due process that appear in the Fifth Amendment did not enshrine a particular form of procedure and allowed for the growth of the law. The court compared due process upon the insistence of the defendant to the words law of the land in the Magna Carta. The defendant's choice was a poor one, as the court was easily able to show the many ways in which criminal procedures in England had changed since 1215. The court went on to hold that an adversarial preliminary hearing before a magistrate afforded the liberties of the defendant enough protection to qualify as due process. Strikingly, the court in Hurtado does not discuss the function or purpose of the grand jury and the circumstances between the amendment. In a sense, Hurtado was an affirmation of the sentiment against the jury system that was common in the late 19th century. For example, the court has also stated in dicta that jury trials were not required in criminal cases by the due process clause. The jury trial was already guaranteed in Article 3 of the Constitution, and the guarantee appears again in the Sixth Amendment of the U.S. Supreme Court, would eventually hold in Duncan versus Louisiana. It's clear that due process, as it was understood by those who wrote the Constitution, required a jury trial in criminal cases. More recently, the Supreme Court that found all elements, sentencing factors, and any other factor that that a jury would need to find at trial must be found by the grand jury in federal cases under the Fifth Amendment. So basically, she's stating here that the jury shouldn't listen to a grand jury unless it's a federal grand jury. Holding was in view of the court's recent jurisprudence on the importance of the jury as a fundamental right to every citizen to protect them against governmental abuse of power. Holding anonymous jury requirement of the Sixth Amendment for a serious offense applies to the states. In view of the renewed interest in the intention behind the jury requirements contained in the Constitution, this court should do what the court in Hurtado did. Choose not to consider the function of the grand jury, how it came to be specifically required in the Fifth Amendment, or whether it is considered a part of the due process when the 14th Amendment was adopted. This court will find that the grand jury could not have been replaced by the preliminary hearing or the probable cause findings of magistrates because the grand jury's main function was not to determine a probable cause, but rather its ability to exercise discretion as to which case were worth pursuing as outlined above. Thus, by doing away with the grand jury, those states that have done so have simply left their citizens at the mercy of the government. What do you guys think? Do you guys think this grand jury that was impaneled there in Idaho, do you think it was a corrupt grand jury? I mean, I do. I think it was a corrupt grand jury. And do you guys think that? Let me know down in the comment section. Do you guys think the death penalty should be thrown off the table because the death penalty can only be brought through preliminary hearing, and there was no preliminary hearing? Yes, he waived his right to a speedy trial, but even with the speedy trial, he is still afforded a preliminary hearing. And Bill Thompson impaneled this grand jury and didn't afford him a preliminary hearing. He went straight to the grand jury for an indictment. Thus, subverting Brian's legal right to a preliminary hearing and a due process. Like always, like, subscribe, and comment on my channel. Hit that bell notification for any new uploads. And it's 48 hours away, guys. This debate with this guilter that I know, and he's already been firing shots, and I've showed 2 of them on this channel. Now, it's Monday night at 8 p.m. Central Standard Time, my time, and he will be on my panel. He's not dual streaming to his channel. I guess he's too afraid to. Like always, guys, you guys have a good Saturday night, and hopefully you guys have a good Sunday. This is Robert with True Crime Podcast, and I'm out. Peace.